not inclined to do so, we would urge that you hold that motion until a later time to determine what remains of the case after the court's decisions on today's dispositive motions.
Okay. And by the way, I had mentioned to you all during one of our previous hearings that I would be open to letting more than one person on each side talk within reason, but certainly I'm willing to relax the traditional rule that only one lawyer per party can discuss. If that gets out of hand, I'll change that, but I'm inclined to do that both ways on that, okay? I think the motion for continuance should be heard first. And then I'm going to allow the plea of the jurisdiction and the motion to dismiss to be heard next. But, Mr. Stevens, it does seem to me, having looked at those, that there is a lot of overlap. And I think it does make sense for the movements on the summary judgment motions to go first on those. And let me, before we hear the motion for continuance, let's discuss the issue. Mr. Stevens, your side wants rulings on the plea of jurisdiction and the TCPA motion. And if I do that and make rulings on those, then that stops the summary judgment dead in its tracks, and that doesn't get reviewed by the appellate court. Is that right? Either way?
Well, if the plea of the jurisdiction or the TCPA motions are granted, then the case is over, so there would be no summary judgment.
How about if I deny those, but sign a written order? Wouldn't that also stop the summary judgment motion?
If there's an appeal of the TCPA, then it would stay the proceedings in the trial court. That's correct, but not as to the PTJ.
Why would that be in the public interest to do that?
Judge, because the purpose of the TCPA is to protect the rights of the parties that are at issue and that we've raised to petition for free speech. And when those issues are raised in the TCPA motion, the purpose of the act is so that the court is to decide those issues before requiring the party to proceed with the merits or with summary judgment or hear the final judgment as the plaintiffs are proposing for summary judgment. And furthermore, it relates to our motion for continuance because the filing of the TCPA motion, which we think should be granted, has precluded either party or in particular us from conducting any discovery that we need for purposes of responding to the motion for summary judgment. And so, as I understand the plaintiff's argument as to discovery, it's that it's our fault. We filed the TCPA and therefore we're not entitled to discovery before responding to summary judgment. We don't think that's at all what the purpose of the TCPA is. The purpose of the TCPA is to get a ruling on those issues before either party has to proceed with merits. And so that's why we would ask the court to rule on that. And then if it goes up on appeal and once the appellate process is resolved, the case comes back down and the case proceeds in the normal course with discovery and then summary judgment once the parties have an adequate opportunity to test the allegations and facts raised.
Wouldn't it also be true, though, that the summary judgment, that the work on the motions for summary judgment has already been done?
There's been briefing on the legal issues raised on summary judgment, but there are significant factual disputes and there are allegations that are supported by facts that are in the exclusive knowledge of the plaintiffs that we haven't had the opportunity to test. And that we dispute, but we can't dispute through affidavits because the knowledge is exclusively within the declarants, the plaintiff's declarants or clients.
Now, wouldn't you expect, though, that after I've heard everything, if I do that, if I think there is a fact issue that would preclude summary judgment on one or more issues, presumably I would follow the law and not grant that. Wouldn't you think? Wouldn't you hope?
Correct, and that's of course what we would ask the court to do, that if there are factual disputes, then summary judgment would be denied. The concern we have is that there are factual allegations the plaintiffs rely on that we can't adequately respond to without discovery, and that's essentially the basis of our motion for continuance under 166 AG is that we don't believe that we're given a fair opportunity to contest their allegations without discovery. On the TCPA ruling, the plaintiffs responded to our request for ruling by identifying several cases that they believe or they argue supports their position that the court can proceed to summary judgment without first ruling on the TCPA. We don't think that those cases apply in this context. And those cases are not in circumstances where a party is prejudiced by not having the opportunity to conduct discovery before going to summary judgment. And we're not aware of any case where a court proceeds to resolve the merits of the case on summary judgment while they're before issuing a ruling on the TCPA in a case where the movement on the TCPA is arguing that discovery is necessary for summary judgment. Cases they cite are not similar to the facts that we're faced with here. So our argument, it would be one of our arguments on appeal, would be that the purpose of the TCPA is to get a ruling and not, it may resolve the case on a motion to dismiss, and then, but not to prohibit a party by filing that motion from proceeding with discovery before the merits are reached.
Ms. Eklund for the non-Planned Parenthood plaintiffs. Your Honor, we are in a unique space here because 2 weeks ago, the defendants agreed to a temporary injunction where they conceded that there was a justiciable controversy and that we were the correct parties and there was threat of imminent harm. At that point, their TCPA motion became frivolous and became sanctionable, frankly. They're taking a position in their plea of the jurisdiction and the TCPA motion that there's no standing as between these two, but between the opposite sides of this declaratory judgment action. We believe it's unequivocally obvious that there is standing and there is a controversy between these two, but that's why there's so much overlap between the merits of this case and the motions that they put forward. At the point at which they conceded the elements of the temporary injunction in form and substance, as they were required to do for an agreed temporary injunction, the TCPA motion became moot, essentially. They've already told this court that they agreed to that in form and substance, that there is a justiciable controversy. The point of the motion today is to stop this case in its tracks so that we have to wait longer to get to the merits. The only thing that they've identified that they need discovery on related to the summary judgment motion is standing. And almost every single thing that they identified that they needed discovery on comes from Planned Parenthood plaintiffs as opposed to the other 13 plaintiffs. Now, strangely, they've taken a position in their response to the summary judgment motion that there were no declarations put in by the other plaintiffs, but that those declarations are in this court's record at least 3 times, including attached as Exhibit A to the temporary injunction that they agreed to. So it's a mystery from our perspective why there would need to be discovery on pure issues of law. The question of standing, we believe, is clear to the court already from the facts and evidence. And there's nothing that they could dispute in that regard that the court doesn't already have access to. So from our perspective, Your Honor, our concern is that that motion is solely for delay. And by ruling, it just stops the merits of this case from being considered when really it's just issues of law.
Ms. Murray, you have anything to add?
Sure, Your Honor. So I would just add a few points. One, to Ms. Eklund's point about the defendant's stipulation to a temporary injunction. Of course, they did that as well for the Planned Parenthood plaintiffs, both with respect to the imminent harm and with respect to the showing made of a likelihood or probable right to success on our claims, probable right to relief on our claims. The other thing that I would say as to Mr. Stevens' point about Rule 166 AG, it is certainly true that that rule provides a mechanism for a party to provide a declaration saying what kind of discovery they need, but it does not follow that this court cannot, in addition to reviewing that request for discovery, decide the summary judgment motion at the same time if it concludes that any of the facts, as is the case here, that the defendants have identified, is not actually material to the resolution of claims. And I would point, Your Honor, to page 10 of our opposition to the TCPA motion, where we do in fact cite cases where there was a motion, a TCPA motion filed by one party and a motion for summary judgment filed by the opposing party. And the court in those cases granted the motion for summary judgment on behalf of the non-movement in the TCPA context, thus mooting the TCPA motion. So there is case law that would provide for that. And I believe that's all we have in addition to what Ms. Eklund said. I would just say one final thing, Your Honor, about standing. I mean, certainly we can get into the specifics of this later in the day, but our clients are the 3 Planned Parenthood abortion providers in the entire state of Texas. They operate roughly half of the facilities in the state providing abortions, and before SB took effect, they all provided.
We may be getting ahead of ourselves here.
I just want to say, Your Honor, to the extent that what you are considering is whether discovery is needed and sort of how to prioritize or order these motions, the argument that it is unclear whether Planned Parenthood abortion providers have standing to challenge SB8 is, I think, in the words of Ms. Eklund, quite frivolous.
I want to hear the motion for continuance first, and then we will move to the motions for summary judgment. And after that, the motion to dismiss and plead of jurisdiction. I think that's the best way to take them up. So Mr. Stevens, go ahead and say what you want to say in support of the motion for continuance. Then I'll hear responses.
Judge, our motion for continuance is a motion for continuance of the summary judgment hearing, and it, while it also addresses our request in part for the court to first rule on the plea of jurisdiction and the TCPA motion, I want to focus on the summary judgment aspect of it because that's the 166 AG motion for continuance. The law is well settled in Texas that a court may grant a continuance of summary judgment and permit a party to obtain affidavits or deposition testimony when it appears from the affidavits of a party opposing the motion that he cannot, for reasons stated, present by affidavit facts essential to justify his opposition. That is what we face here with many of the factual allegations and the affidavits that are submitted by the plaintiffs in support of their summary judgment motion. In particular, we've submitted an affidavit identifying what facts we dispute and what facts we would need discovery on as the basis for the motion for continuance. It's attached to our motion, and it lays out what facts are an issue that we need discovery on. I can give the court several examples. Bobby Kumar is one of the parents or affiants for the plaintiffs, Planned Parenthood plaintiffs. He states in his affidavit that the act will likely bar at least 38 people from getting an abortion in Texas in September alone. That's information that we would inquire at a deposition and seek document discovery from Planned Parenthood as to that allegation. That's something that they're alleging to prove to the court what the effects of the law may be. Another example, they say prior to the law taking effect, approximately 85 to 90% of people who obtained abortions in Texas were at least 6 weeks into pregnancy. There's no way for us to contest that fact without imposing the declarants, Mr. Kumar and Ms. Barraza, Mr. Lambrecht, and Ms. Linton all say that in their declarations. They have a number of other assertions about estimates, predictions of what they think the effect of SB8 will be. We have evidentiary objections to many of those allegations, especially the lack of foundation, but to the extent there is some foundation or there is some basis for those conclusory allegations, we can test them and discover. There are a number of allegations and other statements made by the plaintiffs in their affidavits. They're set forth on pages 5 and 6 of our motion. In addition, the plaintiffs contend that the defendants have an interest in the declaration sought by plaintiffs because defendants are engaging in continued encouragement that others file lawsuits under SB8. We dispute that. We don't know the basis for that allegation, for that statement by the plaintiffs in the non-Parenthood motion for summary judgment. They allege, or they argue, that the UDJA permits pre-enforcement relief if the law has, quote, a direct and immediate impact on its challenger and carries with it the possibility of sanctions. That's a disputed fact and something we certainly contest in discovery. Again, we've not had the opportunity to conduct any discovery because of the pending TCPA motion, and cannot until that motion is ruled on and resolved on appeal. The continuance that we're asking for is to allow us the opportunity to conduct requisite discovery regarding defendants' alleged violations of plaintiffs' constitutionally protected rights. Plaintiffs allege that their patient's constitutional right to privacy is violated by the Texas Heartbeat Act. Determine whether the plaintiffs have standing to even bring that claim. That we need to identify who violated plaintiffs' privacy rights, for example. That's something that they're alleging, but there's no evidence to support it. And if there is any, then we would test it in discovery. They claim that their constitutionally right to sue was violated. Unclear how the defendants, John Seago and Texas Right to Life, could possibly have violated that right. That's, again, something that we would seek discovery to contest. They argue it's that the law is unconstitutionally retroactive. Another example of something we would seek discovery on. The specific or more specific types of requests that we would seek are set forth in the affidavit that I submitted in support of the motion. And there we reference the allegations and statements by their witnesses that they are relying on for their motions for summary judgment. And we also lay out, or I lay out in that affidavit, the specific types of discovery that we think is necessary for us to adequately respond. For example, declarations or depositions of the party declarants, Ms. Barraza, Dr. Kumar, Mr. Lambrecht, Ms. Linton. Those are the 4 declarants or affiants who have offered testimony in support of the Planned Parenthood motion for summary judgment. We think that we need depositions of the plaintiffs or their corporate representatives. We would depose third parties with relevant information to plaintiffs' claims or the information that's referenced in the plaintiff's pleadings, declarations, exhibits, and motions. We would serve written discovery, requesting documents, answers to interrogatories, requests for admission regarding what harm the plaintiffs have suffered as a result or are alleged to have suffered as a result of the actions of the defendants or the Texas Heartbeat Act. We would serve written discovery on the effects of the Texas Heartbeat Act on the plaintiffs. And there are a number of other more specific requests that are laid out in the affidavit offered in support of the motion for summary judgment. So the defendants here, Texas Right to Life and John Seago, would respectfully request or enter a continuance so that the defendants have a full and fair opportunity to conduct discovery and contest the allegations raised by the plaintiffs in support of their motion for summary judgment.
Your Honor, on behalf of the non-Planned Parenthood plaintiffs, I want to point out that he didn't identify a single fact issue with regard to my set of plaintiffs. All of the declarants he discussed were Planned Parenthood folks, and I leave it to Ms. Murray to defend her folks the way that I know she will. But he also did not identify a single fact issue with regard to our case. Our case is a declaratory judgment action that asks this court to decide the rights and legal statuses of the parties, one who contests that SB8 is constitutional, and the other that argues and says constantly on their own websites that it is constitutional and they intend to enforce it. Mr. Stevens just said that they want to know what the basis is for our clients say they're encouraging others. The basis for that is attached in the evidence that Your Honor has in response or in our summary judgment and TCPA responses, which include all of the website postings from Texas Right to Life that they posted themselves to the internet, including the whistleblower website that they set up, including trainings that they held for other attorneys. But they're the source of that information, not anything that our clients could provide. There's no fact issue with regard to the declaratory judgment sought here, Your Honor. The questions are solely whether this law is constitutional on a variety of different bases. There's not a single fact issue that he identified with regard to the abortion funds or the counseling plaintiffs or the individual plaintiffs. The only issue theoretically would be whether there was irreparable harm. But they, the defendants, mooted that issue when they agreed to the temporary injunction. The only relief sought left in this case is a declaratory judgment, and it does not have the same elements as a temporary injunction. Since that has been conceded, since the irreparable harm has been conceded, the only questions now are questions of law, including the question of standing. We're not arguing that Texas Right to Life and John Segal are currently violating our plaintiffs' rights. We're arguing that the law is unconstitutional. And if they were to be sued under that law, it would violate their constitutional rights. We're seeking a declaration as to the status of that law and the status of our client's constitutional rights, given the infirmities with that law. And there's not a single fact issue that has been identified or could be identified that would change that and make a need for a continuance appropriate here. Once again, I just want to make clear the only fact issues that might have existed in the case would have been addressed at a hearing for a temporary injunction. They were not, because the defendants conceded irreparable harm. That means the only question left for this court is the question on a declaratory judgment, whether or not this law is constitutional.
Honor, just a few things to add to what Ms. Eklund said. On behalf of the Planned Parenthood plaintiffs, I would point out the following. First, setting aside the specifics of what Mr. Stevens has argued, his clients do not dispute that since SB8 took effect, it has prevented abortions across the board throughout the state of Texas at any time when cardiac activity is detectable. They don't dispute that. And their own statements, which we cite, we quote, for example, in our opposition to the motion to a continuance, TRTL has stated repeatedly that that point when SB8 applies, the point of cardiac activity, is at approximately 6 weeks of pregnancy. There is absolutely no dispute about who is being prevented from obtaining abortions in this case. I would also point, Your Honor, again, we have this in our opposition to the motion to continue. Mr. Stevens says, for example, that he wants to ask questions of Dr. Bhavik Kumar about his estimates with respect to the number of people who have been prevented from obtaining abortions since SB8 took effect in Texas. They don't need to ask those questions of Dr. Kumar because, again, Texas Right to Life has, in its own statements, admission of the party against its own interests, it has stated in an estimate that we cite in our opposition to the motion to continue that they are estimating SB8 prevented at least 5,000 abortions between September 1st and October 22nd. There is no genuine dispute. This is a delay tactic in order to avoid, Your Honor's final resolution of the facial challenges to SB8 in this case, all of which can be resolved based on the evidence already in the record that is not genuinely in dispute, and on the legal arguments presented before this court. I would say, however, Your Honor, and I think this may be kind of a difference in the way of framing, our argument is that by threatening to enforce SB8 against our clients, which again is well supported by the evidence in the record, Texas Right to Life and Mr. Segal are in fact violating our clients' constitutional rights, both in their capacity as state actors, the state authorized enforcers of SB8. And even if Your Honor does not think that they are acting on behalf of the state, the enforcement, the use of courts and the threat of using this state's courts to enforce SB8 against my clients by Texas Right to Life is in fact an ongoing violation of their constitutional rights under the Texas Constitution. And on that basis, we think Your Honor can enter both a declaratory judgment and a permanent injunction based again on Texas Right to Life's concession that there is a threat of imminent harm with respect to the Planned Parenthood plaintiffs.
Stephen?
Just one issue that's come up now twice in argument by Ms. Eklund, that I think we should address now, because it appears to be significant for purposes of this motion, and apparently their summary judgment motion, at least the non-Planned Parenthood party's motion, is that we entered into an agreement, an agreed order with both parties as to a temporary injunction. And I've heard Ms. Eklund say now twice that it's her position that there are now no factual disputes because the defendants have conceded all of these issues by agreeing to that temporary injunction. That's just so that's patently false. That the order, and we put it in the order for this exact reason, says that we're not waiving any of our arguments or defenses in the lawsuit. So if that's the basis for their motion for summary judgment, and that's the only thing they're relying on, which it appears it may be as to the non-Planned Parenthood plaintiffs, I think the court can just deny that motion for summary judgment right now.
One thing I hear them saying in addition, Mr. Stevens, is that because there was no temporary injunction hearing because of agreement,
Right.
they didn't have a chance, and you didn't take an opportunity to cross-examine witnesses and that kind of thing, which you're asking for now.
That's correct, but I don't think that by agreeing to a temporary injunction to resolve that preliminary issue and give them the relief that they were asking for pending final resolution of the case somehow waives our rights to pursue discovery. I mean, otherwise, anytime a party consents or agrees to a temporary injunction, you can just move to summary judgment and deny that party discovery. I frankly, I'm a little bit surprised that they're trying to game the system by saying that some agreed order has waived all of our defenses when it expressly says it doesn't.
Your Honor.
It hasn't been said, Ms. Murphy.
Your Honor, we agreed to the form of the order that said that they were not waiving their defenses. What I'm saying is that there are only two causes of action for the non-Planned Parenthood plaintiffs in this case. One was a legal action for temporary injunction. That has been resolved. So all the fact issues with regard to irreparable harm are conceded because the injunction is in place. The other thing that we brought, the other cause of action, was for a declaratory judgment as to the constitutionality of the law. While it's true that we still have to demonstrate that we have standing for the declaratory judgment action, there is no longer a question of irreparable harm that existed under the injunction standard. My position is that they conceded that the injunction is in place. We don't have to worry about that standard anymore because all we're seeking now is a declaratory judgment. We filed our motion for summary judgment well in advance of the temporary injunction being set for hearing and the motion for temporary injunction. The motion for summary judgment relates solely to legal issues. There is no factual dispute with regard to whether the law is constitutional or not.
Thank you, Ms. Eklund. Anything else, Ms. Murray, that hasn't been said? That hasn't been said?
Yeah, yes, Your Honor, I'll be very quick. I guess the one thing that I will say with respect to what Ms. Eklund just said to add to is that we are seeking, in addition to a declaration of SB 8's unconstitutionality, a permanent injunction against Texas Right to Life and Mr. Seco. So with respect, that is the scope of the relief that we are seeking, but we think that it is well supported by the evidence before Your Honor. And of course, irrespective of what Mr. Stevens says about their concessions or waiver, the fact of the matter is this court, in our case, earlier found the threat of irreparable harm in ordering the temporary injunction. And there is absolutely no reason for the court to revisit that determination in entering a permanent injunction against the defendants as well.
And that was one of the Travis County judges?
Yes, that's correct.
Was there a hearing on that?
There was, Your Honor, and all of our plaintiffs were subpoenaed. They showed up to provide testimony. And at that point, Texas Right to Life and Mr. Seco refused to testify and stipulated to a temporary injunction, thus, essentially ruling out the very same information that Mr. Stevens now says he needs before summary judgment could be considered by the court.
Word, Mr. Stevens.
Judge, frankly, if their position is that these facts that are at issue in summary judgment have somehow been waived, I can't believe they're making that argument, or that we've somehow conceded everything that we're disputing in our opposition and in the other motions that we filed. I'm a little bit shocked by that. I can't imagine that they want to take that argument up on appeal and try to, sustain some order that resolves this case on summary judgment on that basis. I think they should present their evidence in support of summary judgment, regardless of what happened on a temporary injunction. And, maybe, if there is some case law they think they can rely on about us resolving a preliminary issue in the case, I certainly haven't seen it.
The motion for continuance is respectfully denied. Now we'll move on to the summary judgment motions, and it occurs to me that it might be efficient to deal with all the standing issues at the beginning. And I'm talking about the standing of the plaintiffs to be in court, and the other standing issue, which is the standing of any person to bring one of these lawsuits. Anybody want to? I'm willing to be reasoned with on that, but that seems like an efficient and helpful way to start.
Judge, I think as the plaintiffs counsel has said, a number of those standing issues relate to plea of the jurisdiction as well as the summary judgment. I think it would make sense to just start with the jurisdictional question on the plea, which will address standing, and then when we get to the summary judgment motion later and have to deal with whatever evidence there is on that question, deal with it then.
How's that different from just dealing with standing across the board and then moving on to another issue that might be present in all three, the summary judgment motions and also the plea of jurisdiction and the motion to dismiss?
Well, because the second issue is a merits question. And so the jurisdictional question we would ask the court to address first without addressing the merits or the evidence that the plaintiffs have submitted on that question. It's just purely a question of does this court have jurisdiction on standing?
The merits will come up during the TCPA motion, will they not?
The prima facie case, but I don't think it will go into the exhibits or affidavits to the extent that the summary judgment motion would have to.
May I briefly respond?
Yes, ma'am.
We're happy to take up the standing issues on both sets of issues with the court's permission. This is one of the areas where we would like to have two lawyers potentially speaking, and I just wanted to alert you to that before we undertake it.
I think it makes sense to talk about the standing area of the law first and foremost, and it's both sides are making arguments that some people on the other side, maybe all the people on the other side, don't have standing, although the kind of law may be different. Mr. Stevens, I'm gonna let you go first and present what you want to present on your challenge to the standing of the plaintiffs. And
Okay, Your Honor,
then reply on that, and then we will move to the standing of any person to get into the merits of that. Go ahead.
Ms. Hacker's we'll start with addressing standing.
And if both of y'all want to talk, just as long as you don't interrupt each other, that's okay with me.
Yeah,
And the same thing over here. I think it works best that way. Go ahead.
yeah, sorry, Your Honor. We had divided up according to the motion, not according to topics. So thank you for your indulgence.
Well, is that going to be hard for you to put it all together?
We'll accommodate the court's requests here, but we may have to switch back and forth a little bit. So before the court does anything else in the case, it's important that the court first ensures that it has jurisdiction, which is critical to preserving the separation of powers under the Texas Constitution. The one main reason that there is no jurisdiction here, which I think we should talk about as an initial matter, before we even get to standing, Your Honor, is that the plaintiffs don't have a cause of action here. The plaintiffs have sued the wrong people to get the relief that they want. They've sued two private actors, Texas Right to Life and John Seago. And John Seago is just a guy. He's just a man who happens to be pro-life, who believes that abortion is wrong. Yet he's being sued in this case because the plaintiffs think that the state enacted an unconstitutional law. Mr. Seago is having to defend a state law because the plaintiffs sued him rather than somebody else who was responsible for that. The plaintiffs, and I think an easy way to think about this that illustrates that the wrong parties are here, at least on this side of the beat, is that if Mr. Seago loses, the plaintiffs are asking Mr. Seago to pay hundreds of thousands of dollars in attorney's fees to them because the state enacted what the plaintiffs think is an unconstitutional law. That's just unfair, Your Honor. And Texas Right to Life and John Seago are private actors. And as the Texas Supreme Court held in Republican Party versus Dietz in 1997, and which is also a fundamental understanding of constitutional law, the Constitution only restrains the government. A private party cannot violate the Constitution. And that's whether we're talking about the Texas Constitution or the federal Constitution. Yet here, the plaintiffs have sued Texas Right to Life and John Seago, claiming that those two private parties have somehow violated the Constitution. And again, the Texas Supreme Court said in Republican Party versus Dietz in 1997 that the private, in order to bring claims under the Texas Bill of Rights, you have to have a state actor. Texas Right to Life and John Seago are not state actors. The fact that this law creates a private cause of action does not make them state actors. The Texas courts have never held that. And in fact, if that argument were accepted, that means that all of the other Texas statutes that create private rights of action, under the Natural Resources Code, under the key TAM provisions of the Texas Medicaid Fraud Act, for example, those provisions would somehow create state action. And no court has ever held that private plaintiffs in those contexts are in any way acting on behalf of the state. These plaintiffs here, who have not filed any lawsuits and who in fact have said they don't want to file any lawsuits against the plaintiffs, are not acting for the state, Your Honor. So the plaintiffs don't have any causes of action against these defendants. And I think it's important, just as an initial matter, that the court not get distracted by the plaintiff's arguments about the unconstitutionality of the law, because the court has to first ensure that the right people are here. And Your Honor, the right people are not here.
Help me understand how you got the wrong people being sued. What does that have to do with whether the plaintiffs who are suing them have standing to even be accused?
Because in order to have standing, the plaintiffs have to show an injury in fact that was caused by unlawful conduct of the defendants and can be redressed by relief granted against those defendants. And so the question of whether the right defendant is here can be answered when you look at specifically the causation and redressability prongs of the standing test. So
At least some of the lawsuits had named not only Texas Right to Life and Mr. Seago, but some John and Jane Doe defendants.
yes,
Are those still in the case?
they have not been non-suited, Your Honor. But we don't represent those parties. Those parties are unrepresented and have not been heard.
Even if Mr. Seago and Texas Right to Life got dismissed, then wouldn't we still have the question of whether the plaintiffs have standing to sue the unnamed people that might file lawsuits?
Perhaps Yes, Your Honor, but I think we would also have significant other issues because those people are unidentified and therefore any relief that would be entered against them would violate due process because those people hadn't been heard or given notice.
But I'm just focusing on the standing to bring the lawsuit. Oh, go ahead.
Yes. I mean, I think just in terms of the standing question, you know, one problem I would raise would be that if the, it would be totally speculative as to what injury they're suffering based on unknown people doing unknown things. So I think that would be an initial problem. But going to the standing question, even assuming that there is an injury, and this gets into the merits of the summary judgment motion, but as Mr. Stevens noted before, the non-Planned Parenthood plaintiffs did not submit any affidavits in support of their summary judgment motion that support a claim of injury. So I'll just note that for the court. Even assuming that the plaintiffs have an injury, there is no causation or traceability because there is no action of Texas Right to Life or John Seago that is causing the plaintiff abortion providers not to perform post-heartbeat abortions or the aider and abetter plaintiffs to not aid and abet abortions. The aiding and abetting claim is even more attenuated because it's impossible to aid and abet an illegal abortion if no illegal abortions are occurring. So that's even one chain, that's even one link down in the chain of causation from what we're talking about here. But Texas Right to Life and John Seago have said multiple times under penalty of perjury that they have had no intention, that they had no intention of suing any of these plaintiffs at the time the lawsuit was filed. They don't even know who some of these people are, Your Honor. And an easy way to tell that the harm is not being caused by Texas Right to Life or John Seago is if we imagine what would happen if the court gave them everything that they want. They still wouldn't perform post-heartbeat abortions. If they get an injunction and declaratory judgment against Texas Right to Life and John Seago, there are literally millions of other people that could sue them. They will not change their behavior as a result of any relief this court could grant, so it's basically useless. Now, partially that goes toward the redressability question, but I think it also helps to illustrate why these are not the right people here. Texas Right to Life and John Seago are not preventing the plaintiffs from performing post-heartbeat abortions. The reason that these abortion providers are not performing those abortions is because of the law, not because of the defendants. That does not give them standing to sue the defendants. Another causation problem is that, as the Texas Supreme Court said in 2018 in Myers versus JDC Firethorn, and as the US Supreme Court has held for many years and recently reiterated in California versus Texas, the injury for standing purposes must be traceable to the allegedly unlawful conduct, that's a quote, of the defendant. Nothing that Texas Right to Life or John Seago has done here is illegal. Saying that they support SB 8 is not illegal. Saying that they think abortion is wrong is not illegal. Advocating for the legislature to pass SB 8 is not illegal. Creating a website that asks people to submit evidence of violations of the law is not illegal. And even assuming that SB 8 was completely unconstitutional, if Texas Right to Life or John Seago were to bring a lawsuit under SB 8, which they've said they don't plan to do in front of any of these plaintiffs, but even if they brought a lawsuit and SB 8 was totally and completely unconstitutional, that still would not be an illegal act because Texas Right to Life and John Seago, like everyone else in Texas, has a constitutionally protected right to petition under the First Amendment of the US Constitution and the open courts provision of the Texas Constitution. They have a right to bring a claim under a duly enacted law by the legislature, and that is not an illegal act. So all of these things that the plaintiffs have accused the defendants of doing to cause their injuries are not illegal. In fact, they are protected by the First Amendment of the Constitution. And that's why we brought those TCPA motions, Your Honor, because the whole purpose, the whole underlying basis for their claims and their lawsuit against Texas Right to Life and John Seago is their constitutionally protected activity. And that's exactly what the legislature enacted the Texas Citizens Participation Act to prevent. But going back to the standing question, the redressability issue. As the United States Supreme Court made clear recently in California versus Texas and in the federal heartbeat litigation, courts don't enjoin statutes, they enjoin people, and more precisely, they enjoin people from enforcing statutes, usually government officials. Thus, for plaintiffs' requested relief to redress their injury, it must effectively prevent the person causing their harm from doing so any longer. The relief they want here will not do that. Planned Parenthood admits that any relief this court can give would only apply to the parties here. That leaves everyone else in the world able to sue the provider plaintiffs if they violate the law and to sue the aider and abettor plaintiffs if they aid or abet an illegal abortion. That does not rectify any chill leading the providers not to provide post-heartbeat abortions. And it doesn't give the plaintiffs freedom to violate the heartbeat law. In fact, this relief would be completely meaningless because Texas Right to Life and John Seago, again, have already said they don't have any intention of suing these plaintiffs at this time. And a related thing that the court should consider with regard to standing is that the plaintiffs have also brought a claim under the UDJA. But the UDJA itself, as the Texas Supreme Court said in Chenal, does not confer standing in and of itself. So there must be standing to bring claims before a UDJA action can be brought. So they can't bring a UDJ action and claim that that itself gives them standing. That's not the case. They have to have standing first. They don't, therefore they can't bring a UDJA claim.
Wouldn't the declaratory judgment help them stay in business? That's what they want to do.
No, Your Honor, it
And
would
it
not.
might be ignored, but it might be followed by some people.
It would not help them stay in business because they would not, they've never said, and I believe it's just true as a fact, that they would not, if the court issued a declaratory judgment against Texas Right to Life and John Seago, the provider plaintiffs would not start providing post-heartbeat abortions. And I think another way that you can tell that that's true, Your Honor, is that the Planned Parenthood providers are the only providers suing Texas Right to Life and John Seago. There are a lot of other abortion providers in Texas that are not suing Texas Right to Life and John Seago. So I think that indicates, number one, that Texas Right to Life and John Seago aren't preventing anybody from doing anything. That is the law itself that's having that effect, which Texas Right to Life and John Seago are not responsible for. But also the fact that these other providers are also not going to provide post-heartbeat abortions, regardless of what happens in this case. I would find it extremely surprising as a business matter if the provider plaintiffs would start providing post-heartbeat abortions because they got a judgment against 2 people out of an entire state of millions of people. And again, there's no evidence in this record that if they got that relief, they would start performing abortions again. Now, Your Honor, oh, go ahead. Oh, sorry. Your Honor also mentioned the standing provisions of the heartbeat laws as being related. As Mr. Stevens said, I think that those provisions are more properly considered in the context of the merits of whether or not SB8 is constitutional and not as a jurisdictional matter. But I'm happy to address that issue right now if the court would like.
Yeah, I think that's right. I just thought the concept of standing ought to be dealt with together instead of scattered all over the place. Go ahead and finish it on the other side.
Okay, well, if the court wants to hear.
On your challenge with their standing.
Okay. I think that was about all I had at this time, Your Honor, but I would just encourage the court to think in terms of the fact that the defendants are not the right defendants here. They have not caused the injury that the plaintiffs claim they are suffering, and the relief that this court would grant would be completely ineffectual to rectify the injury that they are claiming here. So there's no standing under established long-standing precedent of the Texas Supreme Court and of the U.S. Supreme Court.
Your Honor, may I approach?
Yes.
Which side is this your the approach to? I know you're stuck in a box. And then I have this here on where on the card. Your Honor, I'm going to address the first issue that you wanted to talk about, which is whether our clients have standing. And then the second will deal with the challenge to SBA itself, and that it doesn't require standing. I do want to correct just a few things, and then we're going to see how good Mr. Anwar is here, because we're going to jump to the evidence, which is actually at the end of this presentation. I just want to note for the court, it's been said several times now that our clients, the 13 non-Planned Parenthood plaintiffs, have never offered any evidence of injury in fact. And that is just patently not true. The defendants seem to believe that this court cannot consider anything on file when it considers the Rule 166A MSJ. Rule 166A allows the court to consider anything that is on file prior to the before the court hears the MSJ, and with leave of court to consider anything that is on file after. Our clients' original declarations in support of the TROs, which were all 3 contested hearings, where defendants appeared and made basically the same standing argument, the Travis County judges. Those declarations were offered into the record at each of those TRO hearings. All of those TROs were granted. They each contain findings about imminent injury, irreparable harm, and a reasonable belief that our clients fear lawsuits under SB 8 from the defendants. Those are also in the record. They were entered by the court. The declarations, the original declarations of our clients were also attached, as Ms. Eklund noted, as Exhibit A to the agreed temporary injunction that you entered 12 days ago. That agreed order was agreed as to form and substance. That doesn't mean that the defendants waived their right to make defensive arguments, but it does mean that they agreed to the findings in substance that this court included in that order. Those findings, again, say that this court found imminent harm, irreparable injury, reasonable belief, and fear that lawsuits were coming. It also contained an express finding that there was a Declaratory Judgment Act claim as to the constitutionality of SB 8, and that our clients had presented a likelihood of success that SB 8 violates the Texas Constitution. In response to the TCP motion, as your Honor knows, we provided a very lengthy appendix of evidence. We did that not because we think that there's actually a need for this court to look at all of that evidence, but we all know this is going to go up on appeal. And with respect to the TCPA, we have to respond to the arguments that they're making. They challenge standing there again, even though that argument's already been rejected. So we put in all of the evidence related to standing. Again, that evidence also contains the temporary injunction, the original declarations, the TROs, and supplementary declarations from several of our plaintiffs who are aware that after Judge Pittman entered an injunction requiring the state of Texas not to enforce SB 8, that there was a 48-hour period during which post-cardiac activity abortions occurred. Several of our plaintiffs have now admitted publicly and in sworn testimony that they are aware those occurred and that they helped facilitate them. Those are in the record as well. The idea that we have not established standing at this point, again, I'm going to echo Ms. Eklund and Ms. Murray. It is borderline frivolous at this point to assert that our clients, whose entire existence is based on helping Texans access abortion care, and who have, since SB 8 was filed and became enacted, have actually admitted to performing an abortion that under the terms of SB 8 is illegal, that they do not have standing to say SB 8 itself is unconstitutional and cannot make my activities illegal. Your Honor, I'd like, if I could, since we gave you so much evidence, I've given you a notebook that has a copy of what we were calling our opening presentation, but given how the court wants to operate, we're gonna jump around.
I didn't realize I was.
No, it's absolutely fine. Again, we have very capable people who will help me. And so what I'd like to do is the first part of the presentation actually goes to the legal challenges to SB 8. So I'm going to jump to the second half and just highlight for you some of the evidence that's already in the record that the court can absolutely consider. And actually, before I do that, let me make this clean. I realize that the defendants have filed objections to our summary judgment evidence. I know we're going to hear those later. I would ask the court to take judicial notice of everything that's already in the file in terms of what has been submitted, including everything that was submitted in the 13 original cases that have now been transferred over here.
Judge, to the extent she's trying to supplement the summary judgment record with evidence that was never offered in support of summary judgment, we object. And to the extent she tries to rely on it, we strike any of that evidence. I can tell the court exactly what she offered in support of a motion for summary judgment because it's listed in her summary judgment motion. For her to now come in and try to say that she gets to supplement the record with, whatever evidence or allegations it may be, isn't supported by Rule 166A. She needed to provide that with her summary judgment motion, which she didn't do.
Your Honor, actually, Rule 166AC says that the court can consider anything on file. And to the extent you're suggesting that we didn't incorporate it, there's a footnote, it's footnote 9, where we incorporate the declarations in support of the temporary restraining orders. We were required to identify anything that is not already on file with the court, which we did.
Judge, I'm probably looking at the same thing you are in Congress on page 714. It talks about summary judgment evidence. Pleadings is proof. As a general rule, pleadings are not summary judgment evidence. Laidlaw Waste Systems versus City of Wilmot, Texas Supreme Court, 1995. Hidalgo versus Surety S&L Association, Texas Supreme Court, 1971. Petitioner answer.
Actually, I'm looking at 166A sub C. Let me finish reading this.
Okay.
Convinced me that I shouldn't be limited to what they singled out for this hearing. Does refer to pleadings, admissions, affidavits, stipulations, contracts, and so forth.
Your Honor, I actually have a Texas Supreme Court case from 2018 that, that says that evidence submitted in a temporary injunction setting was on file for purposes of their summary judgment motion. They approach.
Yes.
It's Lance Robbins.
Lance versus Robinson, 543 Southwest Third, 723 Supreme Court, 2018.
Your Honor, I would also, I'm sorry.
I think I want to go ahead and use our time today. Go ahead and let you all argue. And when it gets to decision time, whatever rulings I make, both sides can look at them and we can argue then about whether I've relied on something that's not admissible and I'll just deal with it at that time. I think that's a better way to do it. Go ahead and save the objections to the end. Just get the arguing done. And I just think that's a better use of our time today. So I'm just going to carry that along. Okay. Go ahead.
Real quickly, judges, with that ruling, is it acceptable to the court if we just have that a running objection so that we don't have to make the objections anytime evidence?
I'm going to do what I said, which is
Right.
make these decisions based on the proper record. And I think it would help me if it comes to that, to let people single out whatever disputed evidence there is. And if it's important to me, and that's one thing, if I think it's inadmissible, I'll just deal with that then. And certainly my intention that you be able to make that objection throughout. You clearly made it, and
Thank you, Judge.
Thank you, Your Honor. And I also just wanted to note the standing arguments made in the context of TCPA motion as well. And obviously, we're allowed to attach evidence to our TCPA response. I just want to make it clear that some of this evidence was attached to the TCPA response. Some of it was attached to the summary judgment.
understood that the summary judgment record and the TCPA record and including the jurisdiction record, those may differ. Time to deal with that is at decision time, not in the middle of this hearing.
Thank you, Your Honor. And so I do want
By the
to,
way, we don't even have to have a record. There's no requirement for oral argument to be reported by the court reporter for that matters. I wanted it for this case for obvious reasons, but at the time that I make rulings and sign orders, we need to have a discussion about the evidence and so forth that my rulings are based on, and be clear about the record, and I will make every ruling that anybody wants me to make at that time. I just think it's better use of our time today to have the arguments, not deal with them.
thank you, Your Honor. I'm gonna try to make this PowerPoint useful for you. And I'm gonna skip to the evidence, because since we're talking about whether our clients have standing to go forward, again, we've put a tremendous amount of evidence into the record in response to the TCPA motion in particular, but also in response to the summary judgment.
Let me just say, it's easier for me to read this as layer, that way, don't worry about that, because I've got it right here.
Okay, terrific. And so what you have before you, Your Honor, and I think if you hop to page 36, what we're endeavoring to do with this, what I hope is final binder we'll give you, is highlight for you the key evidence from all of the evidence that's been submitted. So the first has already been discussed at length by Ms. Eklund. It is the agreed temporary injunction that you entered 12 days ago. Attached as Exhibit A are the supplemental, or are the declarations of our clients that speak to the current injury that is being inflicted on them, which is that they cannot go forward with their business as usual because SB8 creates the ability for the defendants to file lawsuits and hang over their heads financially. They're doing nothing more than their normal business. So there are 12 of those declarations, Your Honor. Again, those were first submitted in support of the TROs that were before the trial courts. And all of those TROs have the findings we've already discussed. The court there found our clients will be imminently and irreparably harmed. Our clients reasonably fear the defendants and those they act in concert with will file claims against them under SB8. That is the harm that is being posed by the defendants here. There are 12 of those. Those are tab 2, Your Honor. Tab 3 are the supplemental declarations I mentioned a moment ago. They were provided in our response to the TCPA motion, again, to deal with this assertion that no post-cardiac activity abortions have been occurring. That is just not true. When Judge Pittman entered an injunction in early October, there was a 48-hour period where those abortions occurred. It was widely reported in the media, and several of our clients have firsthand knowledge that those abortions were occurring and actually assisted in getting Texans access to those abortions. There is no doubt, even the declarations they've now put in say we would only consider suing if people are not complying with SB8. Our clients have now admitted in open court, in sworn testimony, that they are not complying with SB8, that they did not do that while that injunction was in place. And so even under their theory of the case, which candidly is also wrong, because the threat of harm is sufficient for an injury, we've now established that the condition precedent to them not bringing lawsuits is false. Exhibit 4, Your Honor, is Mr. Sego's declaration in one of the federal lawsuits that he put in August, so before these lawsuits were filed. And frankly, it's the reason that
Why
Mr.
don't you tell me what page of your PowerPoint that is?
Oh, I'm sorry. 47. Everyone is telling me it's 47. Frankly, the behavior of Mr. Sego and Texas Right to Life's behavior in August is what prompted them to be named as defendants in this lawsuit, which now only seeks a declaratory judgment on behalf of the non-Planned Parenthood clients. We are supposed to name people as defendants if they have an interest in the declarations that we are seeking. Mr. Sego put in sworn testimony in August in another matter that said Texas Right to Life is publicizing the availability of private civil enforcement lawsuits through social media and other forms of advertising. And we are encouraging individuals to sue providers and funds if they defy the law. They have an interest in whether SB8 is constitutional. They made that interest known before these lawsuits were filed. This is, I believe, August 5th was when Mr. Sego put this in. And the encouragement that he's referring to is the whistleblower website, which is a website that Texas Right to Life created and hosted that was soliciting information and tips and people to bring these lawsuits. This is their own website. It is their own admission, their own statement. This came online in August as well. I'm at slide 88. They were asking people to give them information so that they could organize lawsuits. Our clients took them at their word that they were going to be the people who filed lawsuits under SB 8. They took them at their word because Mr. Sego advocated for SB 8. Texas Right to Life has proclaimed it as their own victory that SB 8 was enacted. They've said that they're the enforcers of SB 8. They clearly have an interest in whether SB 8 is actually constitutional. And the only claim before you for our clients right now is a declaratory judgment. There are two elements for a declaratory judgment. The first is whether there is an actual controversy between the parties. There is. Our clients think that SB 8 is obviously, patently, facially unconstitutional and is therefore void. And is actually not a law because it's void. Because legislature cannot enact a law that violates the Texas Constitution or the federal Constitution. The defendants clearly disagree with that. They believe SB 8 is constitutional. They've now put in a response on the merits, saying why they think we're wrong. They thought SB 8 was constitutional before we filed the lawsuit. They were encouraging people to file lawsuits underneath it. If they didn't think it was constitutional, they wouldn't be doing that. They're still claiming it's constitutional. They're still out there saying that even if you provided an abortion or gave access to help someone get an abortion, while a federal judge had an injunction pending, you are violating SB 8. There's just no dispute that there is a controversy and it's live. Second element is, can that controversy be resolved by the court? Will a declaration from this court resolve the controversy of whether SB 8 is constitutional? Your Honor, a court of proper jurisdiction is the only place where that controversy can be determined. And the Declaratory Judgment Act specifically authorizes this court to make that declaration and declare what the respective rights of the parties are, and to allow our clients to challenge the constitutionality of a statute. As to the idea that what this court does is meaningless, and so there's therefore no standing, I think what this court does matters greatly. I think a declaration by a court that a law is unconstitutional is the proper means by which to get the relief we need. It is this court's duty and job to declare what the law is. And I honestly don't know how to respond to the idea that a judgment that you might render here is meaningless. Of course it's meaningful for a court to determine whether a co-equal branch, the Texas legislature, has enacted a law that is void because it violates the Constitution. Of course it's meaningful. And our clients are the right parties to be here. Their rights are impacted by SB 8. The defendants, through their own admission, worked on SB 8. One of their counsel wrote it. They've been talking to the media for 2 months about what a victory it is that SB 8 is in place and abortions aren't happening. And they specifically said they're going to target people who violate SB 8. I honestly don't know who a more proper defendant is in terms of making sure that the declaration that we're seeking actually has an impact, and they have the right to be here to argue why we're wrong. I also just want to note, Your Honor, so tab 6 are the admissions by the defendants and various websites. Actually, not various websites, they're all admissions from their own websites, I believe. And then I also want to just note for you that, as you know, SB 8 is being challenged in many different places. And it was just before the US Supreme Court 10 days ago in 2 cases. In one of those cases, the Solicitor General for Texas said that a declaratory judgment claim is the proper means by which to challenge SB 8. It's tab 7, Your Honor. And it's not the entire transcript. We did put the entire transcript into the evidence that we submitted to the court. And I will try to get you the page number in the presentation as well. As soon as I can find that specifically for you, I'll direct you to it. Your Honor, in the second case, one of the defendants' counsel actually appeared, Mr. Mitchell did, where he also discussed SB 8. And in briefing in that same case, which we've also highlighted for you in the motion, in the response to the motion, Mr. Mitchell says that the constitutionality of SB 8 has to be decided between private parties because it was designed to not allow you to sue government agencies. So it has to be decided between private parties. He went on to say, and this is on page 95 of the presentation, that there's a danger that a private individual might sue someone under an unconstitutional law, then the remedy is to pursue an anti-suit injunction. That is what we've done. We have done exactly the thing that defendants' counsel told the US Supreme Court is the right thing to do. For all these reasons, Your Honor, we think standing's been resolved multiple times. And I'm happy to continue discussing any questions you might have. But at the risk of beating the dead horse, I'm going to sit down if you don't have any questions.
You have anything to add, Ms. Murray? Anybody?
I do, Your Honor.
Oh, Your Honor, may I just say, it's page 77 is where the Solicitor General's discussion about the private parties suing. My apologies, I'm sorry, I didn't mean to step on your time.
Thank you, Your Honor. I'll try to be brief, but I do want to respond to a number of the arguments made by Ms. Hacker, in particular, the ones that focused and targeted the Planned Parenthood plaintiffs, my clients. So to start, Ms. Hacker says that we have sued the wrong people and that Mr. Segoe is just a guy who's being sued because he happens to be pro-life. That is simply not true. Planned Parenthood, certainly I, and on behalf of my clients, we understand that people come to the issue of abortion care with a variety of views. People are free to support abortion access or to not support it. They're even free to support SB 8 and think it's a good law, or to think, as we do, that it is an unconstitutional law that is violating people's rights. What they are not free to do is threaten to enforce an unconstitutional law against my clients that has the effect of not only threatening a constitutional violation to my clients, but to actually violating the constitutional rights of thousands of pregnant Texans who need abortion. And because of SB 8 and these threats, cannot obtain it today and have not been able to since September 1st, with the exception, as Ms. Myers mentioned, of a couple of days when a federal injunction was in place blocking SB8. During that time, of course, two of my clients, the Planned Parenthood Greater Texas Surgical Health Services and our Planned Parenthood Center for Choice affiliate, it has been reported, and we have this in the record, that both provided abortions during that period of time under the protection of the federal injunction that, of course, was lifted by the U.S. Court of Appeals for the Fifth Circuit. So it is not the case that Mr. Segoe and Texas Right to Life have been sued here solely because, or at all, because they are, we are not, and I do want to make clear where the Planned Parenthood plaintiffs stand on this. We are not suing Texas Right to Life and Mr. Segoe because they advocated for adoption of SB8. We are not suing them because they have talked about SB8 in the media. And we're not suing them because they have decided to retain counsel who may, or it has been reported, was the architect of SB8. We are suing them because they have threatened to enforce SB8 against the Planned Parenthood plaintiffs. And I know Ms. Myers had some of these threats, but with respect to our clients in particular, I do want to direct you to some of the evidence that's in the record. There are a number of Texas Right to Life statements and statements by Mr. Segoe that were attached as exhibits to the Muniz declaration in support of our motion for summary judgment. Those statements include, on July 14th, Texas Right to Life's president publicly declaring, quote, "And after the Texas Heartbeat Act takes effect, we're going to sue the abortionists ourselves," end quote. Then I'm sure, let's see, the Exhibit 6 to the Muniz summary judgment declaration, Mr. Segoe told CNN, quote, "If we do have reports that we do see evidence that they're violating the law," referring to abortion providers, "then we can actually enforce the law ourselves." It is simply not the case that Texas Right to Life and Mr. Segoe have not threatened to enforce SB8 against my clients, who, again, as I mentioned earlier, operate roughly half of all facilities that provide abortion in the entire state of Texas. It is just not credible to say that they didn't have Planned Parenthood in mind in thinking about how to enforce SB8. And nothing that they have submitted to this court has changed or disavowed that intention. I would direct Your Honor, for example, to the declaration by Ms. Cook, who is the general counsel for Texas Right to Life. She submitted a declaration in support of the opposition to our motion for summary judgment. And at paragraphs 12 and 13 of that, she says, "Texas Right to Life fully expected that each of the plaintiffs," so that's including my clients, "would comply with the Texas Heartbeat Act." When they filed their lawsuits in late August and early September, "No rational abortion provider would subject itself to the risk of civil liability under Senate Bill 8. And then she goes on to say in paragraph 13, "For these reasons, Texas Right to Life has never had any intention of suing any of the plaintiffs under Senate Bill A." But that's not saying that they will never sue any of the plaintiffs. It's saying we won't sue you if you do exactly what this law is designed to do, which is to violate your constitutional rights and the rights of patients by not providing abortion care. We would not say, for example, imagine if Texas had passed a criminal abortion statute. It would be no answer to a criminal abortion statute if our clients had challenged that and sued, for example, a local prosecutor. For the local prosecutor to come in and say, "Well, Your Honor, we're not going to, charge them with a felony crime so long as they comply with the law." Of course, that wouldn't be sufficient to effectively insulate yourself from suit. And I would say also to this point about Mr. Segoe, and Ms. Hacker says that it is simply unfair that Mr. Sego might be subject to attorney's fees in the event he loses this case. But of course, it goes both ways, Your Honor. Mr. Sego and Texas Right to Life have threatened to enforce SB 8 against our clients, which, as Your Honor well knows, would stick our clients with unrecoverable costs to defend themselves in that litigation. And potentially, if they were ultimately held liable under the rigged scheme that SB 8 creates, to pay Mr. Sego's attorney's fees as well. So it is just not the case that there's something unfair about bringing claims against Mr. Sego and Texas Right to Life, who have very clearly threatened to sue our clients. The second thing that I wanted to address was Ms. Hacker's statement that Your Honor's ruling would be meaningless. And because we represent the abortion providers, I do want to be very clear about the impact that we think that declaration would have. As we said in support of the motion for temporary injunction, it is true that an injunction against Texas Right to Life and Mr. Sego only will not address all of the harm that our clients are suffering, because as Ms. Hacker said, millions of people could still sue them. And I would note it is not just limited to Texas. It is anybody anywhere in the country who could sue our clients. So it is true that that is not going to address all of their injuries. But it's also the case that under well-established standing law, you don't need to show that the declaration you're seeking or the injunction you're seeking would prevent all of the injury of which you can complain. So long as it is addressing that injury to an appreciable extent, it is, there is standing for the court to enter a judgment. So as to final resolution on summary judgment, our position is that, one, that declaration would bind Texas Right to Life and John Sego, who have been among the most vociferous, who have made some of the most clear threats of suit against my clients. They say that there's no harm because under SB 8, you could only recover $10,000 once. But of course, that ignores what is the threshold harm of SB 8, and that is the threat of enforcement in the first place through these harassing proceedings. So a declaration of SB 8's unconstitutional nature running against Texas Right to Life and Mr. Sego would provide valuable relief to my clients, because it would mean that Texas Right to Life and Mr. Sego could not sue them and force upon them the litigation costs of having to defend themselves in SB 8 lawsuits involving those defendants who would be SB 8 claimants. The other thing that they ignore is that, of course, a declaration, as Your Honor has recognized, can have persuasive effects more generally. It is true that some people may not honor a declaration of invalidity against someone else, but lots of people would, and more importantly, some of their attorneys might as well. So I do think that it would have both an appreciable effect in removing an actual concrete injury to our clients from Texas Right to Life and Mr. Sego. It would have a persuasive benefit more generally because of the value of the declaration. And of course, if this, Your Honor has, and I think all would recognize that this case is going to go up on appeal. And of course, whatever the Texas Supreme Court does, its statements about SB 8's constitutionality or unconstitutionality would bind courts throughout the state. And that, of course, would have much greater effect, even if it is not an immediate impact. So I do think that a ruling is valuable. It would help our clients get back to focusing on the work that they do and are trained to do to care for patients in need of abortion throughout the state of Texas. And then the final point that I would make is with respect to Ms. Hacker's arguments about the declaratory judgment claims.
So it's just not true that a court can't consider constitutional invalidity as part of a declaratory judgment action between private parties. And that makes good sense, right? I mean, if you had, for example, a law that said Mr. Kaplan could take Ms. Myers' house, she wouldn't have to wait until Mr. Kaplan comes and like tries to change the locks. It would be no answer to that law to say, well, you know, yes, it's completely unconstitutional that the legislature did this, but you can't have a declaratory judgment between the private parties. Of course, that would be wrong, and it's wrong here too for the same reasons. So I do think that a declaratory judgment action is available here, even if Your Honor is thinking about Texas Right to Life and Mr. Sego as purely private parties. But as we have said in our motion for summary judgment and in our opposition to the TCPA motion, they are not, in fact, acting as purely private parties. It's not the case, as Ms. Hacker suggests, that if you treat them as state actors in this case, because they are performing an exclusive function of enforcement of abortion bans and sort of standing in the shoes of the state, or using the machinery of the courts to enforce an unconstitutional law, it's not the case that saying that that is state action as it is would mean that any key TAM plaintiff, for example, or any other plaintiff relying on a private right of action would itself be engaged in state action. There is a well-defined standard for what constitutes state action when undertaken by nominally private people. And we go through that case law in our opposition to the TCPA motion. But it is just not the case that it would sweep in all of those other private rights of action as they suggest. SB 8 is a unique law, and this court can and should determine that its mechanism of essentially pushing enforcement onto the general public for anyone, no matter how untrained, how unrelated to the abortion, that is in fact conferring the authority to act on behalf of the state, and it should be treated as such. With that, Your Honor, those are the only additional points that I would make.
Take a 10-minute break.
All right.
Good to see you.
Yeah. Y'all come together. I guess this is not down, so it's probably close to the other. I don't know. 3 hours.
Do you know if there's a Coke machine downstairs?
There is, all the way by the cafeteria.
Okay, thanks.
Well,
Do you want anything?
I'm just gonna go get some more. It was fine. We left. We left. It was only 1 hour time, but careful when you go in there. When it's over there, yeah. We left at like 7:20, a little bit later than we wanted to. We like traffic was so bad, and I was like, we want to stay late. Right. We want to wait. So, and then we stopped every hour. We had to get time on a walk. Okay, so this year has been 90%, which was like way so much more than I could do. And work. So you got a little rest. I know, she's all. Yeah. Thank you so much. Well, no, they don't. Yeah, well, y'all are taking, y'all are killing.
So I saw your expression here a few times. You were like, you keep looking around and you're like,
well, no, I'm like, you're like, I'm going all out. I don't care.
say how I. I've never even heard.
Never even heard of it. Small items, like,
30.
that's my new line of shit.
It goes the same, second good check. It goes the same.
Oh, that's good.
All this is.
Oh, nice.
Driveway. That's not at the airport.
If you can either do, I'm coming back next.
I know she's.
Why are you looking at me like that?
No, that's not.
Did I have to come back?
That's why we're
Yeah, so I, Band's not banned, but.
Yeah, just because I haven't heard something.
A bunch of bands were playing, and it's like, hey, $10, or it's kind of like $7, so. I had a really appreciate what they want. Like, I know there's a lot of probably like our voice on board process. Yeah. Yeah, it's been, I try to tell my clients, so I watch out, but I'm an administrator, but they like, and so then I'm like, it's been too much of a mess. I need to get that happened once. It's kind of like so like you said. No, well, no, but you have to, so that and our and our credit card, they really don't want address. We have to go in together.
Yeah, we had to go into that.
I can't believe these ads we just need to follow up on the news website.
Would you ever do that?
So I'm just like, I'm like, get me on that.
Make sure you're.
Yeah, exactly. Get on that now. You just.
Yeah, I'm gonna do refill on water.
Thank you so much. Oh, absolutely.
Nice to meet you.
Just a couple of brief responses, Your Honor. There were two very important things that were absent from both Ms. Murray and Ms. Meyer's presentations. The first thing is that I didn't hear anything explaining how a single thing that Texas Right to Life or Mr. Seago has done is illegal. Nothing that they've described to this court as to the reasons why Texas Right to Life and John Seago have been sued, none of those things are illegal. That is required under the standing analysis. And again, I direct the court's attention to Texas Supreme Court 2018 Myers versus J.D. Firethorn, U.S. Supreme Court California versus Texas. Their injury must be traceable to unlawful conduct of the defendants. Everything they've said that Texas Right to Life and John Seago have done is not illegal. And not just that, it's actually affirmatively protected by the Constitution of both the United States and Texas. All of that is protected First Amendment activity, which again, not to preview coming attractions, but that's just what makes this a prototypical case under the Texas Citizens Participation Act. The second thing that I didn't hear anything about in either Ms. Myers or Ms. Murray's presentation that I think is fatal for their case is that there was nothing explaining how an order from this court would cause the plaintiffs to change anything about their behavior. They are not going to start performing post-heartbeat abortions as a result of anything this court will do. Their injury, therefore, is not redressed by any order of this court. Ms. Murray said that an order from this court, a declaratory judgment, could be persuasive upon others. That is the epitome, Your Honor, of an advisory opinion. Certainly anything a judge says may persuade others, may persuade lawyers, may persuade the public. But it is a long-standing factor of both Texas and federal law that judges do not issue advisory opinions for that very reason. What they're asking the court for is essentially an advisory opinion because it will not redress the harm that the plaintiffs say they're suffering, and it will not prevent any person other than Texas Right to Life and John Seago from suing the plaintiffs. An order of this court is not binding on anyone besides Texas Right to Life and John Seago. An order of this court is not binding beyond Travis County. And an order of this court will not redress the injury they say they are suffering by not being able to perform post-heartbeat abortions. Another thing I wanted to address is that Ms. Murray said that Texas Right to Life and John Seago have threatened that they will sue the Planned Parenthood plaintiffs. I believe that is a disputed fact, Your Honor, because in the declarations that Texas Right to Life and John Seago submitted, they said they had no plans to sue the Planned Parenthood plaintiffs, and I don't believe there's been any evidence presented to specify any threats made expressly against the Planned Parenthood plaintiffs. So to the extent we have competing declarations or contentions by the parties, that fact is essential for deciding this case, and that is a disputed fact that would preclude summary judgment. Another point that I wanted to address is that Ms. Myers said that she questioned how we could say that the plaintiffs don't have standing to bring this lawsuit. Your Honor, the plaintiffs are obviously very upset by this law. They are obviously upset by the actions of Texas Right to Life and John Seago, but that doesn't mean that they have standing to sue these defendants. These defendants have to be the right ones in this case. Now, as far as the references go to the argument in the U.S. Supreme Court, I was there in the room, Your Honor, and I don't recall any admissions that anything going on in this case is the proper avenue or approving the validity of anything going on here. I would point out that a reference to being decided between private parties and whether that is the proper avenue for deciding this case. I believe that that would have been in reference to being asserted in a defensive posture. Because, Your Honor, that's a fundamental flaw in this case and the federal cases. It's because they're trying to do this in a pre-enforcement posture that they're running into these problems with standing. Certainly, if Texas Right to Life did sue one of the plaintiffs could raise all of their arguments about unconstitutionality in the context of that proceeding, and there would be no standing problems because the injury would be there, it would be ripe, it would be proper as to those defendants, at least not that I can think of standing here today. That is the proper posture for raising the arguments that they make. The problem here is that it's being asserted pre-enforcement, and that's how they're trying to sort of shoehorn this in to the existing standing doctrines, and that's why it just doesn't work, Your Honor.
Would it be your position that nobody would have standing to make a pre-enforcement challenge to this law?
I think it could be possible depending on what the facts are, Your Honor, but I think that based on the facts, I think it would be difficult, but I think, there could be a possibility that there might be facts that could allow for that. I don't think that those facts are present here, Your Honor.
Let me put an admittedly unlikely hypothetical. Suppose legislature decides to pass a law saying anybody who files to run against one of us can not do that unless they get pre-clearance from a committee we set up. And somebody who wants to run says, I'd like to run, and this is stifling my ability to talk. Surely that person could go to court and get a pre-enforcement, pre-licensing declaratory judgment and or injunction, wouldn't you think? I mean, I find it hard to believe that where everybody agrees on the constitutionality or unconstitutionality of something like that, the law would deny standing to someone who truly is affected by it and who's holding back for fear of being sanctioned. I mean, it seems to be the principles you're arguing for would make that wannabe opponent of an incumbent legislator give that person standing.
So I think I'm going to start with just a general principle, and then I'm going to answer your direct hypothetical as you've asked it. The general principle is that there is not a right, either under Texas law or federal law, for pre-enforcement review. And constitutional rights are often asserted defensively. But going directly to the hypothetical that you've asked, I think that would be different because there would be identifiable parties that are, right, there would be a candidate that's one person and there would be an opponent that would be one person. The person suing wouldn't be trying to get relief on behalf of a bunch of unknown people. I think the other thing about it is that if in fact that would be clearly unconstitutional, which it sounds like it would be to me, then
It'd be enforced by private people that have an incentive to do it.
right, then
Could be.
I think if I'm understanding the question properly, then I think that would certainly present different facts, but I would also point out the fact that there wouldn't really be any reasonable fear of enforcement that could cause any liability because the law is so clearly unconstitutional.
Well, I
So,
guess I could add to my high flow that any person could be authorized to sue and get damages. If somebody doesn't go through the licensing scheme, that kind of thing. And if you transplant these rules, these procedures to other areas, seems troublesome to me that there would be no standing for someone. And in this case, I don't remember the doctor's name. One of the plaintiffs is a doctor who says I perform abortions. Why wouldn't he have standing if he says I've been stifled and chilled by his law?
Because his chill is not being caused by Texas Right to Life and John Seago.
But would he have standing to seek a declaratory judgment issued to the people of Texas?
No, because a declaratory judgment under the statute cannot be issued as to parties who are not made, or to people who are not made parties to the proceeding.
And they've named, I think it was 100 people. They don't know their names, so they call them John and Jane Doe, I think. And stand-ins. Would that not be a way to issue it to people who might want to bring one of these SBA lawsuits?
No, Your Honor, that would violate due process because John and Jane Doe's 1 through 100 are not parties to this proceeding and have no notice of any judgment being entered against any of their rights.
Thank you. Go ahead.
So one quick point about Ms. Meyer's presentation. She said several times that this is a void law, but that is a misstatement of how the law works. I believe it's the writ of erasure fallacy. A judgment of the court does not declare a law void, does not remove it from the books, does not erase a law. All it does is prevent enforcement of an unconstitutional law, which is why redressability is such an important factor to consider in whether the court even has jurisdiction to entertain these challenges. Ms. Murray's example of this being in a criminal law context that we would expect people to be able to raise a pre-enforcement challenge there. I would say that situation is factually distinct, and I think there's a lot of case law on this point that because of the fact that if you're being threatened with prosecution, first of all, the case law says that there has to be an imminent threat of prosecution. And also there's a presumption that applies to district attorneys or state officials that they will in fact enforce the law. So I think that example is of limited relevance to a case involving a private right of action. So I guess just to sum up, Your Honor, I would reiterate my point earlier that the Texas Right to Life and John Seago are not the right defendants here. The court does not have standing, or the plaintiffs don't have standing, and the court does not have jurisdiction because nothing they've said has explained to the court how there is causation under the law, because nothing Texas Right to Life and John Seago have done is illegal. Certainly the plaintiffs don't like what they've done, but that does not make it illegal. And in fact, it is protected by the First Amendment. And also we've heard nothing from them to explain how they would change their behavior to eliminate their injury, which they say is not being able to perform post-heartbeat abortions. If this court issues an order in their favor. Persuasive authority from an order of this court is not a reason to exceed the court's jurisdiction under the Texas Constitution. And asking the court to issue an order that's not binding on anyone else because of its purported persuasive effects is the epitome of an advisory opinion. And the court should resist that temptation.
Very briefly, then we'll move on to something else. We've got to pace ourselves.
Thank you, Your Honor. I promise I'll be brief. I won't even go to the lectern. With all due respect to Mr. Mitchell, who wrote the law review article that Ms. Hacker just referenced, the Texas Supreme Court has said that a legislative act that violates the Texas Constitution is void. The Texas Court of Appeals in Dallas in 1987 said the same thing. As recently as last year, the Texas Court of Criminal Appeals said the same thing, and then the Texas Supreme Court said it again. It is just absolutely not true that the legislature can enact a law that violates the Constitution and have that law be valid. With respect to the elements in standing for declaratory judgment. Again, there are only two elements for a declaratory judgment. An actual controversy as to the rights and status of the parties, that a declaration will actually resolve the controversy. There is clearly a controversy between the parties before you about whether SB 8 is constitutional. Your declaration can resolve that controversy. Specifically with respect to standing under the Declaratory Judgment Act, plaintiffs must show a particularized, legally protected interest that is actually or eminently affected. Our client's interest is being affected right now. They are having to change their behavior because SB 8 unconstitutionally exposes them to financial ruin, which the defendants are very happy about. It's not as if the defendants have come in here and said, they're right, SB 8 is unconstitutional. We will not ever bring a claim under SB 8 because it is unconstitutional. What they've come in and said is we'll do exactly what we want as long as you do what SB 8 tells you to do. You can't moot an actual controversy by coming in and saying, well, don't worry, I won't do the thing that you're worried about as long as you do the thing that I don't want you to do. You look at standing as of the time the lawsuit was filed. At the time it was filed, all of the evidence in the record, including Mr. Sego's declaration and all the admissions from Texas Right to Life's website, indicated that they were going to sue under SB 8. They can't now come in and say, well, as long as you just do what we want. We didn't mean that. Of course they mean it. It's why they haven't come in and said, absolutely on the record, we will never sue under SB 8. One issue with respect to the actual harm inflicted, Your Honor, again, deprivation of a constitutionally protected right is a harm. The imminent threat is injury in fact. Frankly, Mr. Mitchell conceded that in briefing in the federal court system as well. He said it's an injury in fact under Article 3 to have your constitutional rights chilled. The idea that he's going to say that in federal court and then come into the state court and say, actually, it's not, and I realize he's not here, but you can't put in those competing assessments of the law. In terms of the actual immediate financial threat, Ms. Murray was correct in her presentation when she talked about the financial burden of having to defend against invalid, frivolous lawsuits that are created solely by a statute that violates the Texas and US constitutions is a real financial harm. It exposes these plaintiffs and her clients to financial ruin, which Mr. Sego and Ms. Cook have said in their declarations. They don't expect anyone would violate SB 8 because of the financial ruin imposed. That is a real harm. I neglected to mention to the court a harm that is being imposed separately from that, which is there's a provision of SB 8 that is codified at the Texas Civil Practice and Remedies Code, section 30.022. And we'll talk about this more when we get into the constitutional challenges. That provision makes any person who seeks a declaratory judgment that any abortion regulation, including SB 8, is in fact unconstitutional. It makes them liable for the other side's costs and fees. It also makes any attorney who deigns to represent them in a pre-enforcement challenge jointly and severally liable for their costs and fees. Literally every person before you on this side of the courtroom is subject to a claim for fees that they are seeking. They ask for it in their TCPA motion. They invoke a provision of SB 8 against our clients and against us. The idea that there's no harm being caused, again, it's hard to fathom how that's possible. I forgot my other points, John. So I'm gonna sit down.
Your Honor,
So I just have 3 points, and I will try to be brief. Ms. Hacker said there's a general principle that you're not entitled to pre-enforcement review of a constitutional challenge. I would direct your honor to In re Abbott, which we cite in our briefing. That's 601 SW3 3rd at 812. And that makes clear that plaintiffs who are seeking pre-enforcement review of a challenged law can do so where they have an intent to engage in a course of conduct that's constitutionally protected but proscribed by the challenge law. Each of our clients, the Planned Parenthood plaintiffs, have an intent to engage in the provision of needed abortion services to Texans, but for SB 8. And those services are constitutionally protected both by the federal constitution and the state constitution. The second point that I would make in response to Ms. Hacker's presentation, she said a couple of times, the plaintiffs have said they're not going to change their behavior, but that is not the analysis for standing. This court's opinion would not be advisory, and it would not just have a persuasive value to others. Although I will say, as to persuasive value, again, I would direct your court to a case that we cited in our briefing, Steffel v. Thompson. That's a U.S. Supreme Court case, 415 U.S. 452, in which the U.S. Supreme Court recognized that declaratory judgments, of course, can have persuasive value beyond the parties who are actually in a lawsuit. But even if you set aside the persuasive value of the declaratory judgment, Ms. Hacker does not dispute that her client's behavior would be changed. They say in their declarations, oh, we're not planning to sue your clients because we know they're going to comply. For that reason, we're not going to do it. But of course, if your honor enters a declaration of SBA's unconstitutionality as against Ms. Hacker's clients and permanently enjoins them from enforcing SBA against my clients, that would in fact change their behavior by preventing them from something they have threatened to do. I would also direct your honor, we do have evidence in the record from the Planned Parenthood plaintiffs about the harm that comes not just from the threat of suits if our clients were to violate SB 8, but from the threat of suits even if they're trying to comply based on perceived violations of the statute. So I would direct you to Ms. Linton's, the declaration of Melanie Linton at paragraphs 14 and 15, and the declaration of Ken Lambert, for example, at paragraphs 18 and 19. Those declarations talk about the threat of harm that comes even if our clients are trying to comply with SB 8 because of the targeting of abortion providers and of course the very real possibility that untrained individuals, including Texas Right to Life and Mr. Sego, will perceive a violation even if there has not been one. And third, to your hypothetical, Your Honor, I think you are exactly right to be troubled by the possibility that if you transplant the procedures of this rule to other areas of the law, the argument made by defendants would still apply under Ms. Hacker's theory, and it would bar people from suing. I think at bottom what defendants are saying here is that because the state has made the harm so widespread, because it didn't say you, local prosecutor, you can enforce this, or you 10 people can do it, it said millions of you, even if you're not Texans, you can come and enforce SB 8, that somehow that, because the threat of harm is so overwhelming that no one has standing to challenge it. Because of course, even if someone else, Ms. Hacker said, maybe someone else, if they had clearly threatened to sue the Planned Parenthood plaintiffs, maybe then you could have a pre-enforcement challenge. But that makes no sense under her theory, because of course, if in that circumstance, I'm sure they would still make the same argument that a declaratory judgment isn't going to bind the millions of other people who could sue them, and it's not going to stop those people from suing. So I think this pre-enforcement challenge distinction that the defendants are trying to draw doesn't work even under their own theory of the case. Their theory really would prevent any effective review of SB8's constitutionality. With that, I have nothing further.
Let me ask you, Ms. Hacker or Mr. Stevens, that any person, there's been reference to anybody in Texas or beyond, two places in the briefing. I think one was the reply to the summary judgment motion. The other was the Tcpa motion. The statement was made that anybody in the world could bring one of these suits. That's the position, I think. Not any Texan or any American, but anybody in the world.
I mean, I think that, if I'm not mistaken, I think that SB8 says any citizen.
Says
or
any
maybe
person. And it makes a distinction on venue. It says, you know, you can sue where the defendant lives and so forth, where the event took place. Or if the plaintiff is a natural resident of Texas, that person can sue in his home county. But that's a distinction between if any person is a Texan, they can sue in their county. That implies that other people wouldn't be able to, they don't have a county to sue in. But twice in pleadings signed by Mr. Mitchell, the statement was elsewhere in the world or anywhere in the world. And I'm just wondering if that was, is your position.
Well, I would say, Your Honor, that any person means any person. That's what the statute says. This question, I think, goes to the merits of SB8. But I will say that the idea that standing, so Texas law allows standing to be conferred by statute. So that's something different than what we're talking about here. What we're talking about is the constitutional standing issue, but under Texas law, the Texas legislature is free to confer standing by statute, and it has done that in several other occasions. SB8 really isn't that unique in terms of creating a private right of action. It's unique in that it applies to abortion. But there's 100-year precedent in the Texas Supreme Court on the idea of private citizen, any citizen enforcement of a law. And that's discussed in our briefing, Your Honor.
I think I'd like to move to that part of the challenge to SB8, that is standing of any person and the $10,000. But you pretty well. We have basically half a day left, and more than that, we go after dinner or through dinner. So, and I need to leave some time for the motion to dismiss and the plea of the jurisdiction to be discussed. Whatever's left over on those that hasn't been discussed when we finish the summary judgment. So, what issues do you all want to take up next? We go till about 12:15 and then break for lunch.
Your Honor, I'd argue that standing in terms of SB8 is probably the next most logical issue because it involves some of the same case law and Texas constitutional provisions.
Let's go ahead and let me hear from you all first on that.
Could I, just in terms of ordering for things that could be heard, we would be interested, Your Honor, in making sure that we get to talk about the non-delegation claim that's at issue in the summary judgment motion, which has some overlap with standing, but not entirely.
Okay, go ahead.
In our binder that we provided to you earlier today, there's in the slides, I just want to direct you to the language of the civil liability provision that affects standing under SB8, just so that we have this as a reference as we talk. I think what was just discussed is relevant here more so than anywhere, which is that SB8's provisions, including the civil liability provision at bottom, perhaps the most important one,
challenge the integrity of our entire legal system. They do that by making our system of checks and balances out of whack. They do that by seeking to preclude judicial review. And the real issue with all of the constitutional challenges that we have brought on behalf of our counseling plaintiffs, the individual plaintiffs, and the abortion funding plaintiffs. The truth is that all of those challenges, if you superimpose them on any other issue, any other constitutional right, they would still be equally problematic. It doesn't matter whether it's abortion or it's the right to own a gun. It doesn't matter whether it's free speech or another clearly protected right. These procedures imposed on any constitutional right are unconstitutional for their own reasons. And that therein is where this question of standing becomes the most obviously important one. Ms. Hacker made the comment that the Texas legislature can confer standing at will. That is not accurate insofar as there's a qualification to it, which is that when the legislature confers standing, it must be within constitutional limits, which their own cases provide. The constitutional limitation has been interpreted by both the Texas and the United States Supreme Court. The United States Supreme Court, while considering Article 3 standing, which I concede is not the standing we're talking about here, but the TransUnion versus Ramirez case made very clear last year that there had to be an actual injury to a claimant for the courts to have the authority to hear the case. The same really is true under Texas law. There are certain very narrow circumstances in which the Texas legislature has conferred standing, but in those instances, there is always an injury. If you look at the KVUE provisions, which confer standing on folks to bring actions on behalf of the government, there is an injury to the government. And the person is given the standing to take that injury and move on behalf of the government. The government also notably retains an interest at that point, which they have explicitly disclaimed with regard to SBA. If you look at taxpayer cases, the taxpayer has to demonstrate that they have in fact paid taxes and therefore can challenge the government's actions and how they've used those taxes. There has to be an injury to their constitutional rights regarding the use of their funds as a taxpayer. The only case cited by the defendants, which suggests that there doesn't have to be any injury whatsoever, is a 1915 case about a brothel in El Paso. In that case, the plaintiff did allege injury. The plaintiff alleged that it was a nuisance that was depreciating the value of their property, and the court said, you can confer standing. We look to the legislature to tell us what to do. In every case since then, and I would direct your honor to a string site that is in the Best Buy stores for, through Danucci versus Hagar case, which is out of the Austin Court of Appeals. The court goes at length, Judge Justin Howell, to talk about all of the cases in which standing has been conferred and the exceptions to the general rule that there must be injury. And as he says in that opinion, the Texas Supreme Court has held that the legislature cannot set a lower standard than that set by the general doctrine of standing because court's constitutional jurisdiction cannot be enlarged by statute. Herein is the problem, Your Honor, is that the question of standing dovetails into the problem of separation of powers. And standing has to be enacted, even if it's conferred by statute, within constitutional limits. And the open courts provision of the Texas Constitution provides specifically that the courts will be open to individuals for injury done to them. There is no injury for an SBA claimant. There doesn't have to be. What SBA does is create a strict liability tort where any person, Texan or not, can go into court and claim $10,000 because they know an abortion has taken place. In fact, they can go into court 17 times if they know 17 people who had anything to do with that abortion. That's what this statute does. There's no injury whatsoever to the government or to the individual who's claiming it. And there's no requirement that there be an injury. That the Texas legislature cannot do under either the United States precedent under Article 3, which is informing of the Texas Supreme Court's decision-making in the process. But the Texas Supreme Court has held repeatedly that The legislature can confer standing within constitutional limits. And here we are way beyond the constitutional limits of requiring that there be an injury and requiring that the courts be open and requiring, frankly, that any random individual can, at the state's behest, but without the state's involvement, walk into court and somehow uphold the state's interests as it's laid out in SB 8. That has never happened before. There's not precedent to rely on for this court to determine how and why that's problematic, other than what I've directed your honor to in terms of the constitutional requirements and limits that necessitate an injury take place. And the only exceptions that exist in terms of Texas law conferring statutory standing do not disclaim the requirement of an injury. SB 8 requires no injury or even connection to the abortion at issue. And the particularization requirement with regard to injury is really, I mean, I'll go down a rabbit hole if I go too far, so I won't. But the exceptions to the rule and the key tam provisions, the taxpayer case, even the El Paso case from 1915, is the question of whether the injury has to be particularized to the individual, not whether there can be no injury whatsoever.
That statute in 1915 said any citizen.
I don't know the answer to that, Your Honor. It was an ordinance in El Paso that allowed it. I think it was any taxpayer in El Paso to raise it.
Okay, so the ordinance, not a statewide statute.
That's right. The other problem that I think is patently obvious on the face of this statute is that the state doesn't have the ability to confer standing or power that it does not have. While our challenges to SB 8 in terms of the abortion funds and the individual and counseling plaintiffs do not take on the 6-week ban on its face, Supreme Court precedent for the United States is clear, and Casey and Roe very clearly demonstrate that a 6-week ban is beyond what can be regulated. The state has chosen to give the right to any person to go enforce this ban because they know they can't do it. They can't do it. It's an end run around the constitutional rights of women who need abortions, but for my plaintiffs, for the abortion funds, for the counseling plaintiffs, for the individuals, for the doctor, it's an end run around their own constitutional rights as well, which is detailed in our motion for summary judgment and our petitions, which include the right to free speech, petition, assembly, and so forth. New York Times versus Sullivan did say explicitly by the US Supreme Court that the state cannot do by civil statute what it can't do in a criminal context. And that is exactly what SB 8 has attempted to do. The next problem in terms of standing with regard to the civil liability provision here is the $10,000 bounty or penalty, although it's referred to as statutory damages. We provided Your Honor with briefing, I believe, on the question of whether the $10,000 amount is more properly characterized as penalty or damages. And I believe the Supreme Court precedent in Texas demonstrates that it is more properly characterized as a penalty, but it makes another point with regard to standing. One is there's no injury. There's also no duty inherent in the statute as SB 8 is written. So there's no way to calculate what a measurable damage would be. Rather than operating as a damages award, which would compensate for the non-existent injury, it is akin to a criminal penalty. In fact, it's a criminal penalty in excess of what a felon might receive. There's no way for the court to know how to adjudicate or measure damages since there is no injury requirement. And it's intended as a deterrent, not as compensation. I also think it's important in light of some of the arguments made last week in the United States Supreme Court on the issue of outrage, that we take into consideration that under Texas law, mental anguish damages are almost never recoverable and only in very narrow circumstances. I know the state of Texas has chosen not to appear before this court to be heard on the issue of whether this law is constitutional, but to that end, to the extent that it is meaningful, I would like to point out to the court that the damages associated with someone's mental reaction to knowledge of abortion would be very difficult to prove in any normal setting. SB 8 does not require them to prove anything at all. It doesn't even require them to be damaged. It's an unconstitutional statute because it completely dispenses with the idea of standing in terms of our civil tort system. The standing issue is also problematic, as I noted before, with regard to the separation of powers under the Texas Constitution, and it can't be detached from that problem. Essentially, the legislature has displaced the judiciary, even by the argument that pre-enforcement review is almost never going to be possible, according to the defendant's theory of the case. It eliminates the judiciary's role in deciding what the law is. The Uniform Declaratory Judgment Act makes very clear that a court can decide a controversy about the constitutionality of the law as between two parties who are interested. And I'll leave the dead horse that we've beaten on the issue of standing to the side for now, but it cannot really be claimed that the parties on either side of this have an interest in the constitutionality of the law. The law is specifically written to evade judicial review, not only at a pre-enforcement level, but also in defensive posture. Because, as my co-counsel mentioned, every person who raises the issue of constitutionality and every lawyer who helps them to do it will be liable and responsible for the fees associated with the other side if they don't prevail on every single claim in their case. That's unheard of under Texas law or elsewhere, and it deprives clients of the opportunity to raise meritorious defenses without being worried about that burden. It also deprives those clients of counsel if they can't find someone who's willing to take that risk on with them. The legislature has also supplanted the executive with regard to standing here. Typically, the executive would enforce the law that the legislature puts forward. Here, that is specifically disclaimed. There is no involvement by the government in recovery. And so, as the defendants and their counsel have argued, there's no state defendant that is appropriate to sue in order to determine the constitutionality of this law. But the executive, in an ordinary case, would be hampered by an early injunction, because even though only the one party would be enjoined, let's say a district attorney, the decision that a court made with regard to constitutionality would have a ripple effect as to every other district attorney. That's the whole point of deciding constitutionality. Mr. Mitchell's writ of erasure fallacy conceives of a world where we don't take cues from the judiciary as to what is lawful conduct and what is not, and only those particular parties are bound. But that is not how the American judicial system has ever worked in practice, and it's not how it should work simply because the Texas legislature decided to deprive the state of any involvement in the case. Further, the statute deputizes private citizens to do the work of the executive. Notably here, also an end run around the constitutional rights of the people affected, because the state itself could not do it, because the constitutional rights of its citizens would be impacted. The defense argues in their response to the summary judgment motion that separation of powers is not applicable here because deputized citizens get the power, not another branch of government. But that misses the point with regard to separation of powers, Your Honor. This highlights the usurpation of the legislature of the other powers of government. Even though there's a new entry into the branches of government, apparently, from the deputized citizens of Texas and beyond, those are not really a co-equal branch of government. And by deputizing folks to do what the state cannot do, the legislature has told the courts what they can and cannot do. It's told state actors that they cannot enforce. It has taken power away from the other two co-equal branches and conferred an attempt to confer standing on any other person who wants to exercise that power. With that, Your Honor, I'll stop for now. To the extent that Your Honor wants to take a look at the Best Buy case that I referenced, it was filed on April 16 of this year. I believe there's no petition on review at this point, but it does have a really nice layout of all the cases on both constitutional conferral of standing and the narrow exceptions.
Is that in the briefing that I've gotten so far?
It is, Your Honor.
Thank you, Your Honor. So I'm not going to go through what Ms. Eklund just very ably did on the standing piece. I think we generally agree with everything she said. I would note with respect to the cases on which defendants are relying that she addressed, to some extent, that each of those cases dealt with a statute that allowed any person or citizen to vindicate an injury to the government. Whereas here, as she said, there is no assertion that there is an injury at all to the people who are permitted to sue under SB 8. As Ms. Eklund, what I would like to focus on, and I think Ms. Eklund talked about it a bit, is this issue of non-delegation, that SB 8 is effectively an unconstitutional delegation of power to private individuals. And I think I've provided to the parties and to Your Honor a couple of handouts that we created basically to help the court hopefully match the claims that we have brought to the specific kind of features of SB 8. And then in the second handout, that handout goes specifically to the test for whether a delegation of government authority to private parties is an unconstitutional one. And I think it does have an overlap with standing. Much of what, as I understand Your Honor's concern with the attempt by SB 8 to create standing for individuals where there is none, I actually think that the most effective and kind of streamlined way to think about that is not as a quote unquote standing claim or a standing issue, but as the manifestation of why SB 8 is an unconstitutional delegation of authority.
Delegation.
I do, Your Honor, for a couple of reasons. I think that the delegation, it is in this context where we are making the argument affirmatively in a pre-enforcement context, I think that the case law is just quite clear where a statute confers authority on private parties, and we've laid out, and I believe it's a little small there, but the 8 factors that the court would consider. I think that the case law on that is just incredibly clear that this is an unconstitutional delegation. So, for example, as I said, there are 8 factors that the Texas Supreme Court has laid out in the Bull-Weevil case. We cite that at the bottom. It then, of course, reaffirmed those 8 factors in the FM Properties case, also cited at the bottom of the handout. And defendants have said in their briefing that this standard, as Ms. Eklund indicated, doesn't apply because, the private parties here, essentially the delegation an unconstitutional delegation is only problematic if it's taking power from one branch and giving it to another. And this is sort of something wholly different. But I actually think SB 8 is kind of doubly bad in that respect, because Ms. Eklund is absolutely right that the act tries to take executive authority that would normally be exercised by the governor and the attorney general and give it. So it takes that authority to the legislative end, but then it confers it back out to private parties. So the fact that private parties are involved does not in any way indicate that the non-delegation case law from the Texas Supreme Court is inapplicable here. And in fact, the Bull-Weevil case very clearly sets out the factors that you should consider in the context of a private party. So I do want to go through those individually. We have here the factors in bold, and then underneath those factors, our responses or application of those factors to SB 8. So the first one is, of course, are the private delegates' actions subject to meaningful review by some branch of the state government? And SB8, the answer is clearly no. In fact, the statute says, go forth, private enforcers will have nothing to do with it from here on out. Factor 2, are the persons affected by the private delegates' actions adequately represented in the decision-making process? Of course not. Here, the regulated parties, abortion providers, and those who could be liable for aiding and abetting conduct prohibited, they aren't represented in what came out of the legislature, and they certainly are not represented in the multitude of decisions that could be made, including on behalf of Texas Right to Life and Mr. Sego, to enforce SB8 against them. They also, for factor 3, SB8 gives private individuals not just the power to rely on SB8, but to actually apply it to individuals. And it gives them a pecuniary, for factor 4, it gives them a personal interest in enforcement of SB8 that would be in conflict with whatever the state was trying to accomplish. Here, of course, we know that that was actually a violation of constitutionally protected rights, but it doesn't have to be the case that an SB8 claimant shares that view. Of course, you know, we have seen from the one abortion that was performed by a non-Planned Parenthood provider in violation of SB8, that person has been sued by someone who very clearly says he's in it for the money. And he, you know, if there's $10,000 to be had, he'll be there every time. So for factor 4 as to a delegation, it very clearly SB8 gives a pecuniary interest to individuals to bring suit for money or to kind of grind an ideological axe. For 5, you know, as Ms. Eklund said, we do think that the penalties here, the statutory damages, are actually penalties and are quasi-criminal in nature. 6, is the delegation narrow in duration, extent, and subject matter? Far from it. SB8, of course, allows people to sue anywhere. Anyone who has violated SB8, they can do so indefinitely, and they can file as many suits as they would like without ever having to be responsible for paying the other side's attorney's fees. So it incentivizes suits in a broad range of circumstances. For factor 7, does the private delegate possess special qualifications or training for the task delegated to it? I think this is where the delegation argument actually really intersects with the standing argument in a very close way, because of course, by authorizing any person to sue, SBA doesn't require any training. I realized after we did this, there is one exception other than government officials who can't bring suit, and that exception is someone who caused a pregnancy through rape or another crime. That is the sole exception for who is quote unquote unqualified to enforce an SBA claim. Otherwise, people have free reign to bring suits. And factor 8, has the legislature provided sufficient standards to guide the private delegate in its work? Again, the answer to that is plainly no. This is a free-for-all, what SB8 has created. And the entire goal, what Mr. Sego has said, I can get you the site if you need it, is that the only way it works is with a credible threat of suits from anybody against abortion providers like my clients. That's what makes it work, and that is also what makes it an unconstitutional delegation. The Boll-Weevil case that we cited, for your honor, the one thing that I would also focus on in that case is that, one, it did not involve just what one would consider legislative authority. The foundation in the Boll-Weevil case also had authority to impose sanctions, so similar to an executive authority, and it had authority to conduct inspections of premises. So I believe that the defendants have tried to distinguish that case on the ground that it involved the delegation of legislative authority to private individuals, but I don't think even on the facts that it can be distinguished in that way. And of course, we cite other non-delegation cases in our briefing as well. It's not just the Boll-Weevil case. So one, boll weevil involves authority that could not be described only as legislative in nature. And two, boll weevil makes clear, and I think this is why we think it is perhaps the clearest, cleanest way for you to resolve the claims in this case. Boll weevil makes clear that where an unconstitutional delegation is involved, that delegation is itself void. And boll weevil is an example, I believe the FM Properties cases as well. Facial invalidation of the statute is the appropriate remedy for that. So if Your Honor were to decide that SB 8 is an unconstitutional delegation of executive authority to private parties, you could facially invalidate that delegation of authority, that of enforcement authority, across the board in SB 8, and you would then not need to consider, our own view, all of the ways in which particular aspects of the enforcement proceedings violate due process, violate the right to equal protection. We believe that those are meritorious claims too, but I think there's actually a very simple way to resolve the enforcement piece of this case, and that is by holding that SB 8 imposes an unconstitutional delegation of authority to private parties. And I believe that that would get at what I understand to be some of Your Honor's concerns with respect to SB 8's attempt to create standing where there is no injury to the person bringing a claim, and giving to that person not only the ability to collect $10,000 or more per abortion, but to obtain an injunction going forward against conduct that violates SB 8, even if it has absolutely no effect on the SB 8 plan. With that, Your Honor, those are the only points that we have on non-delegation. Certainly happy to answer any questions if you have them.
Judge, your question, you asked about the standing provision and whether it's constitutional. And to frame that discussion, the argument the plaintiffs are making is that that the Texas legislature is constitutionally forbidden to confer standing on uninjured persons. That's our understanding of their argument. That under the Texas Constitution, the legislature does not have authority to confer standing on someone unless that individual has some injury or has met the standing requirements that they think bind the legislature. That's false. The case law does not support that. What they're doing is they're trying to argue that federal standing requirements are the same as the standing requirements under the Texas Constitution. You asked about the 1915 case. There's a long line of precedents dating back to the 1915 case that establish that the Texas Constitution allows the legislature to confer standing by statute, and that standing can be conferred by statute upon any person, any taxpayer, or any citizen. That's what SB 8 does. It's consistent with the Spence case from 1915, which was cited with approval by the Texas Supreme Court in 1966, and then also cited with approval by the Third Court of Appeals, which is binding on these proceedings, in the Grossman case more recently. And that was the Grossman case was the 2019 case from the Third Court of Appeals in Austin. Those cases and the line of precedents the precedent that relies dating back on Spence create a standing analysis that is different from the analysis that would apply under federal law. So to address that issue, we think it's fairly straightforward that the case law supports exactly what SB 8 does as to the constitutionality of the legislature conferring standing on any citizen.
Let me be sure I understand what you're saying, and I have read.
Right.
That Spence case was long and old. But the Scott case and the Bell versus Hooter, the 1984 case of the Supreme Court, just have incidental references to ordinary standing rules unless there's something different by statute. And they say basically that. And the question I have, and I simply don't, I need to dig deeper. One thing for the court to say, we've got these usual standing rules, which require injury and so forth, unless there's something different in the statute. Because it is certainly true that the legislature can change the common law in many, many ways. I don't know whether it's the same thing, and I'm interested in your argument on this. I don't read those cases to say whatever the legislature does to create standing is okay with us, no matter how far it goes, because I don't think they say that. They may mean that, but I don't think they've said that, and I don't think they've had those kinds of statutes before them, like this one, which not only gives standing, I think the newspaper said yesterday we have 17 million registered voters. So I don't know what the number of adults in Texas is. You add to that adults in this country and conceivably around the world. And the standing that is granted is the ability to get a mandatory injunction and also mandatory damages. I'll have a discussion on this too. Ordinarily, when a plaintiff proves $10,000 worth of damages, once that amount is paid, you can't get the same thing from additional defendants. If all you've got is 10,000 damages, you don't gain anything by suing 5 people. If you get 10,000, you can't go get another 10 for a total of 50. But under this law, you can, because there's no harm linked to it. So I just am wondering if the standing question, the SB 8 standing for any person, is really answered by those cases that, admittedly, 3 of them by the Supreme Court. And then I think that the response to the motion for summary judgment mentioned others that have the phrase that mentions unless the statute says otherwise. But I'm just struggling and want help on whether it is the Supreme Court's position that we're going to stand back no matter how far standing is granted if the legislature does it, which it seems to have done here. So that's just, that's a long question, but it's something that is on my mind. I think the statute and the cases raise that question.
I think that's right, Judge. But I don't know how far the Supreme Court would extend that precedent. Would there be some limit on those cases? Perhaps, but there's not under existing law that, as we're here today. And the Grossman case, I think, does address at least part of your question, where the court says that, and the court relies on the earlier cases, Spence and Scott, the third court, and says that the individual has standing to sue to restrain and enjoin violations, even though he has not suffered a particularized injury distinct from the general public. And so that was the issue, and that question was raised there, and the court, at least the Third Court of Appeals, went back and said, well, the Supreme Court has said in those cases that the legislature can confer standing, presumably, even if it's the individual who is provided standing by statute has not suffered injury distinct from the general public. So I think that the body of case law that is binding as we address that issue here is fairly well established on the question. You'd asked about the standing question, and then I think that plaintiff's counsel also argued delegation issue. The delegation question, and again, we think that that there's no jurisdiction to consider these arguments, and that's obviously why we've urged the court to consider and rule on plea to the jurisdiction first. But it said that the court finds it does have jurisdiction and is considering these questions. The delegation issue, I think is a different, well, the first question is they sued Texas Right to Life and John Seco. And Texas Right to Life and John Seco haven't delegated anything. It goes back to what Ms. Hacker was arguing, that they're suing the wrong people here. John Seco may have been provided some authority, or if that's their argument, to sue under SB 8 by the legislature, but he's not a defendant who is delegating anything. They originally sued legislators. Maybe those would be proper defendants, maybe not. They dismissed the legislators from the case. But I don't think there's any way they could say that John Seco and Right to Life are liable for an unconstitutional delegation of legislative or executive authority. It's just not possible. And there's no case law that would ever support that. Now, as to if they could bring that claim against John Seco and Texas Right to Life, then the questions of whether their problem is with the law itself. It's not with John Seco or Texas Right to Life's delegation or non-delegation or involvement with that issue. Even if they could bring that claim against John Seco and Right to Life, my understanding of their argument is that delegation that they allege, that they believe that it's unconstitutional because it violates the separation of powers provision under the Texas Constitution. And that's the basis of the constitutional claim that they're making on delegation to John Seco or to anybody else. In that, the argument first, it disregards what the text of the separation of powers provision of the Texas Constitution says. That provision of the Constitution applies to a delegation to an individual between the legislative, executive, or judicial branches. It doesn't apply to private actors. And so that is, I think, to a certain extent, consistent with the argument that they're suing the wrong person here as well, because there is no delegation to someone within those branches, at least as that provision of the Texas Constitution is written. There's a question, at least raised by the non-Planned Parenthood plaintiffs, about eliminating a defense, that SB 8 eliminated any defense that SB 8 itself is unconstitutional. That's not an accurate argument as to what the statute does or does not do. But in any event, that doesn't affect the separation of powers argument or the delegation of power to private parties. That our understanding of the claim they're making is that it violates the separation of powers provision, and the separation of powers provision doesn't apply in this context because there is no delegation to another branch of the government. And I haven't seen any case law that would suggest it in this context that it is violated.
I need to read that Boll Weevil case, but I think what they're saying is that if there's a delegation to private parties of something that would have been an executive function, like prosecuting, under certain circumstances, that's not valid.
Right, and I don't think those circumstances exist here, and it appears that they take the other position on that. I believe those were the two challenges that they argued in response to your question. There are others that I imagine that we will get to, or that they would argue. But that's our position. That's our position. It's laid out in our motion for summary judgment. We don't think these are as complicated of issues because we think the case law is clear on the standing question that you raised, and we don't think it's complicated on the separation of powers issue because the provision, Texas constitutional provision they rely on is clear that it has to be between the parties who are members of those branches.
Before you sit down, let me, I want to direct a question to both sides. There's a reference to existing law. And I want to be sure my understanding is correct on a couple of things. Number one, the cases before me, everybody has agreed that I'm not asked to say, make any ruling on the Supreme Court area of abortion law. It could be before this court, but it's not. Am I right? And you're nodding your heads affirmatively on the.
We are not challenging it for the non-Planned Parenthood.
That's okay with you all, I'm sure. Susan?
I think Planned Parenthood is, but I'll let Ms. Murray speak to that.
So, Your Honor, we have brought exclusively state law claims, but one of our claims is a right to privacy claim under Texas law on the ground that SB 8 bans pre-viability abortion. And we have cited in our motion for summary judgment cases in which the Texas Supreme Court has relied on Roe v. Wade and the right to privacy established under federal law to interpret and give meaning to what that state law right would be. So it is correct that it is not before this court whether, as a matter of federal law, SB 8 violates a right to privacy or substantive due process. It is, however, before this court whether SB 8, by banning pre-viability abortion and by putting at issue a patient's personal medical care and decision-making in litigation with strangers, whether those two aspects of SB 8 violate state law right to privacy.
Thank you for that clarification.
And I would add, Your Honor, although federal law is not directly at issue, I do think, of course, some of our claims rely on the fact that SB 8 is not, for example, like a key TAM statute that is furthering a public interest or a public good. It is a statute that is directly targeted at a right that is unquestionably protected by federal constitutional law. So although we're not asking Your Honor to make a ruling on that question, it is certainly part and parcel of some of the claims that we are making, because we're saying SB 8 is not furthering a legitimate public interest, for example, for equal protection purposes. The sole purpose and effect of SB 8 is to prohibit the exercise of a constitutional right. And we think that the court can, of course, take stock and notice of what federal constitutional law would unquestionably provide here.
I could reply to the question of whether SB 8 is furthering a legitimate public interest fairly easily by saying that I think that's a significant matter of dispute, that the Texas legislature and many members of the public would believe that SB 8 in fact does further a legitimate public interest. And so if Ms. Murray's suggesting that that is an undisputed fact or is somehow necessary for purposes of her getting summary judgment or her motion for summary judgment on the right to privacy claim or the federal claim in a row or under some state constitutional right to access abortion, that the purpose of the law and whether there's a legitimate public interest is certainly in dispute.
The phrase existing law also, maybe you want to ask this question. Would I be right in saying that there is no existing law squarely on point? The point being a statute that has several procedures that have never come together before. Unlimited standing, automatic damages with no harm, the fee shifting, venue where the plaintiff lives, automatic injunction, things like that. If a statute like this one had ever been enacted in this country, ever before, we would know about it and there would be some law on point. Am I correct about that?
I'm not aware of a statute that has each of the components of this law that are being challenged. So I think you're right. If there were, I imagine it would be,
And,
part of the litigation.
on this side, you agree? So we've got bits and pieces that deal with
Right.
the bits and pieces if you fragment and look at them one by one. But
Yes, that's our understanding, too.
yeah,
This is the
it's never
first
been
time that all
gathered
of
together
that's.
before, and that's the reason that there's not any factually the same statute and case that we have in this case.
I think that's right. And I think there's an important follow-on point to that, which is that in SB8, there's a severability clause,
Yes.
that express, and I can't quote it, but it's in the statute. And the implication of that is that if a court finds that any one provision or any of these issues we're talking about today is
Every
unconstitutional.
section, every sentence, every word, every punctuation mark.
Right. Then that unconstitutional provision is severed from the constitutional provisions. And
So
so,
the Supreme Court case on that point is cited in the statute.
right.
11, I think, yeah.
Right. So,
Let's go ahead and break for lunch, and is an hour long enough? Get back at 1:10.
In your offices. Oh, I ordered it.
Okay.
I'm like, what I did.
Gotcha.
Huh? Oh, you got here? I don't know if you know.
Well, they wouldn't pick ours up and they're coming back. I wonder if anyone's going overflow.
Often